Are you interested in applying for naturalization but are worried about a prior arrest or crime affecting you? In our last videos, we talked about travel issues and fraud issues that could affect your naturalization. Now let's get into the nitty-gritty when it comes to crimes. Besides travel, the biggest area that usually results in immigrants being thrown into removal proceedings from a naturalization interview is due to a crime that appears on their record that CIS may not even have ever known about. If you had never traveled outside the United States, or if you had never applied for naturalization, and thus they never had to run your prints before. Even if you had previously run your prints with immigration to renew your green card and you had the crime on your record, the case law may have changed so significantly since that period during which your prints were run, so as to interpret a crime you committed as now having deportation consequences, even if the crime didn't have any consequences before. So if it was safe at the time you pled, that it didn't have any immigration consequences, that may have changed now. Maybe you had a crime that could have been considered a CMT, and there was no case law categorically finding that crime to be a CMT or a crime of moral turpitude, but in the last 5 years, the courts or the Board of Immigration Appeals have concluded that it is. And for permanent residents who commit just one crime of moral turpitude within 5 years of entry with a potential sentence of 1 year or more, that is a deportable crime. If a permanent resident commits 2 crimes of moral turpitude at any time since becoming a permanent resident, even if it was 20 years ago, 25 years ago, you've paid your restitution, you've paid your dues, your probation, everything's done, regardless of the potential sentence, even if you got no jail time whatsoever, the green card holder can still be deported. And just because you're applying for citizenship and you've been a green card holder for many years does not mean that the naturalization officer is not going to not only deny your case, but actually place you into removal proceedings. And don't trust necessarily that a naturalization officer knows the latest case law that may save you from a negative CMT determination. They may prefer that you argue your crimes are not crimes of moral turpitude or are not deportable crimes in front of an immigration judge and then just issue an NTA at the end of the interview to literally kick the can down the road. Let the immigration court figure it out, and then eventually you can come back to us if it all gets sorted out in your favor there. But even if you have expunged your prior crimes in the state court, which can help for your employment, it can help for criminal record when you're applying for certain benefits, it doesn't help you when it comes to immigration. They will still show up in your naturalization case, and they still count as convictions for immigration purposes. So always get your criminal history reviewed by an immigration lawyer to know the pros and cons of going forward with filing for naturalization. And if you can afford it, hire an attorney to work with you through the process and represent you at the interview if you decide to file for naturalization. Here's wishing you the best of luck and hoping you too can become a U.S. citizen soon.